Hello, everyone. This is Corey Alford with Sunrise Law Group, and today I wanted to talk to you about who inherits the estate if there is no will, and who will inherit the estate if there is a will. Let's go ahead and start with someone who had a will. In that case, you would simply carry out the wishes of the will of whom the deceased wanted to inherit the estate. If the will is invalid in whole or in part, or if the will does not dispose of all the deceased's property, then the property will be disposed of according to Louisiana law. What if the deceased did not have a will? Who will inherit the estate? In order to determine this, we must first determine if the property is community property or separate property. Louisiana, as you know, is a community property state, meaning in most cases, property acquired by married persons will be considered community property, and each spouse owns an undivided one-half share in that property. An example of community property could be a house bought during the marriage. An example of separate property could be a house bought before the marriage. So let's say that you have a married couple with two adult children. When a married spouse dies, the surviving spouse will keep their share of the community property and will receive use of the deceased spouse share of that property. That use of the property will last until the surviving spouse either remarries or dies, and the children will receive what is known as naked ownership in the deceased share of the property. Regarding the separate property, the separate property will be divided among their side of the family, whether it is their children, parents, or siblings. If the deceased died with no children, the deceased share goes to the surviving spouse. Thus, the surviving spouse owns the entire property outright as their property. If you have any questions about this or any probate related questions, please just let us know. We'd be happy to help.